Hello, my name's William Steinwhittle, and I'm a staff attorney with the Foreclosure Legal Assistance Project in the statewide Advocacy Support Unit at Maryland Legal Aid. Today we are going to discuss three main issues: a motion for relief from stay, which is filed by a creditor, a motion to modify the Chapter 13 plan, which is filed by the debtor, and an affidavit of default, which is filed by a creditor after a debtor defaults on a motion for relief from stay. A motion for relief from stay is filed by a secured creditor when a debtor defaults on post-petition regular monthly payments. So the creditors that generally do this are cars, HOAs, and mortgages, because a debtor has a post-petition responsibility to continue the regular monthly plan payments after a Chapter 13 is filed. So they can't just stop paying their mortgage, the regular monthly payment, just simply because they're in a bankruptcy, for example. Then the creditor can file a motion for relief from stay. The creditor's goal in filing a motion for relief from stay is to lift the stay so they can proceed against a secured asset. So basically so they can sell the house, sell the car, etc. Because the bankruptcy prohibits them from doing it. A motion for relief from stay can also be filed in a divorce case if the bankruptcy is keeping the divorce from moving forward. Motions for relief from stay are dealt with differently in Chapter 7s as opposed to Chapter 13. In Chapter 7, secured debts are not really part of the bankruptcy. It's a liquidation bankruptcy, which basically means you get a discharge of all of your debts, but you can't reorganize your debts, which means that basically you can't cure pre-petition defaults of secured debts. What this means is if a motion for relief from stay is filed in a Chapter 7, this will have to be dealt with outside of the bankruptcy unless the trustee finds that there's equity in the property, which would result in the sale of the property for the benefit of the creditors. In a Chapter 13, you do have options to resolve the motion for relief from stay that do not result in the loss of the property. But before you do any of those options, you must file an answer. If you do not file a response, then the court will enter the motion for relief from stay judgment by default, and the creditor will be able to proceed and sell the property, which is ultimately their goal in any motion for relief from stay. So you need to file a response. This response must respond to everything that is stated by the creditor in their motion, and you must also list any defenses or on how you're going to fix the current default. The standard is strict, so basically if you've missed the payments, then you don't really generally have a defense. That doesn't mean that you don't have any options, however. The options are reinstatement and repayment plans and motion to modify. A reinstatement is when you cure the entire default that's claimed in the motion for relief from stay. This is generally not a great option because it's generally a relatively large amount, but if you were to come into a lump sum such as a tax refund or other lump sum, this may be an option for you. A repayment plan is when you continue to make the regular monthly payments on the secured debt, and then you cure the remaining amount in a 6 to 12 month period. This is generally not a great option for mortgages because mortgage payments are so large, but is generally a decent option for HOA payments and cars. However, before you agree to anything in regards to a vehicle, you may want to consider if keeping the vehicle makes sense. The next thing that we're going to talk about is a motion to modify the Chapter 13 plan. This motion is filed by the debtor after their Chapter 13 case has been confirmed. It can be filed for many reasons, such as a material change in circumstances in regards to their income, such as a change in family size or a change in job. It can also be filed in a response to a trustee's motion to dismiss. So if you're in default to the trustee, you can file this motion to attempt to cure that. We are going to focus on filing this motion in response to a motion for relief from stay filed by a secured creditor due to a post-petition default. The first thing, if you would like to resolve your motion for relief from stay in this manner, is that you need to reach out to the creditor to see if that is an available option to you. Most creditors will agree, but it is not guaranteed. If the creditor does agree, they will provide you with a consent order, which will provide you with a certain period of time in which you need to file a motion to modify the Chapter 13 plan. If you do not file the motion within that time period, the motion for relief from stay may return, so it is very important that you abide by the deadlines that are provided by the statute. Then, you should also read over the consent order to make sure that all of the information is understood and that you understand your responsibilities. It is always best to consult with an attorney if you have any questions or terms that you do not understand. You should file the motion to modify the Chapter 13 plan within the time provided by the consent order. The motion must contain the motion to modify and must also contain the consent order explaining why you are modifying the case in this particular manner. You must also clearly state how the payment is going to change and what the new payment will be. Generally, a motion to modify results in a larger payment. However, this can be alleviated in some cases because you are permitted to extend the terms of the plan to 60 months after confirmation, which, if it took a long time for your case to be confirmed, could provide an additional time for the amount to be paid. In addition to filing the motion, you also must file a notice which clearly states a hearing date. The hearing dates in the District of Maryland are available on the court website. In addition, you must serve all of the parties to your case, all the creditors and all of their counsels and the trustee. The motion is not automatically approved by the court. The trustee must consent to it. So if the trustee consents to it, the hearing will be removed. However, if the trustee does not consent, then you will need to fix whatever issues there are to get the trustee's consent. You can still go to a hearing to contest any questions and issues the trustee has, although please understand that the trustee's word has a lot of weight, and that generally it's going to be difficult to get a modified plan approved over the trustee's objection. If the modified plan is approved, court will then issue another wage withholding order if they are withholding your wages from your job to pay the corrected amount. During the pendency of the motion, you must continue to make your trustee payment, and you must pay the new trustee payment as required by your modified plan. The final thing that we're going to talk about today is an affidavit of default. An affidavit of default is filed by a creditor after a debtor has defaulted on a previously agreed upon resolution to a motion for relief from stay. So this would mean the default on a modified plan, or on your post-petition mortgage payments after a modified plan, or on the consent order that resolved the motion for relief from stay. The options in regards to this are much more limited than the options are for a motion for relief from stay. Generally, you only have 10 to 12 days to cure. The amount of cure time is provided for by the consent order on the motion for relief from stay. However, you can extend that by filing a response. So I urge you to file a response to at least give yourself more time to cure the amount. Generally, however, you will have to cure it in a lump sum either within the 12-day period or within the period provided for by your answer, which will be set by the court establishing a hearing date for the affidavit of default. Occasionally, they will agree to a motion to modify a plan to resolve an affidavit of default, but it is rare. So it is best to avoid an affidavit of default if possible. Thank you. I wish you the best of luck in the bankruptcy process, and the best of luck and success in your bankruptcy and in your financial situation.